1.4 Hate speech. Hate speech means insulting, abusing, and promoting hatred against religions, communities, groups, etc. So recently, National Crime Record Bureau report says that the cases under the hate speech law is increasing daily. So, based on this news, we will now know about the complete details of hate speech. So, here, um, the International Covenant on Civil and Political Rights. So, this is actually an international human rights treaty which enables the people to enjoy a wide range of human rights. So, this body has defined about the hate speech. We find the definition of hate speech only under this body itself. The hate speech is not defined in Indian law or the international law. The term hate speech includes insulting, harassing, promoting hatred or discrimination against groups through any means of expression. So, the legislations that are provided about this hate speech are: first is Article 19, Clause 2. So it says that the right to speech and expression are subjected to restrictions for public order, decency, or morality. That means this article, that is 19 clause 2, restricts promoting of hate speech. And the next is the sections 153A, 153B, 298, etc. under this International Penal Code 1860 deals with the hate speech, the punishments of hate speech. Okay, it deals with the punishments regarding the hate speech. And the next is Representation of Peoples Act 1951. Even this Representation of People Act 1951 prohibits a person from contesting in elections if he is involved in hate speech. So section 123 clause 3A and section 125 under Representation of People Act 1951 prohibits the hate speech on the grounds of religion, race, caste, community, or language. And the next is Protection of Civil Rights Act 1955. So under this section 7 of Protection of Civil Rights Act 1955 punishes a person who is involved in encouraging untouchability through any type of expression. So now let's look at these are the cases regarding the laws which are regarding the hate speech. One is Article 19 clause 2, and the next is IPC 1860, and next is RPA 1951, and the last one is Protection of Civil Rights Act 1955. Now let's look into the disadvantages or issues with the hate speech. The first point is it spreads violence against people, especially the community violence. And the next is it increases religious conflicts. And the third is it impacts the social harmony and democracy. And the fourth one is it disturbs the law and order of the society. So now let's look into the challenges in countering the hate speech. The first is there is a clash between the freedom of speech and expression and hate speech. See, if a person of any community is speaking against any community is a hate speech, right? But under Article 19 clause 2, a person has freedom of speech and expression under a reasonable restrictions. So here there is a conflict between hate speech and freedom of speech and expression. Okay, so see, I belong to one community, so I don't like the acts which are done by the other community, so I criticize them. So that can be taken as hate speech, and that can also be taken as Article 19 clause 2. That means I have the freedom of speech and expression, right? So there is a conflict between both the freedom of speech and expression as well as the hate speech. Okay, so the as definition, the correct definition is not present in our constitution. There is a frequent clashes between these two. And the second one is curb dissent. So here there are different opinions regarding the hate speech and freedom of speech and expression. There is a confusion between these two, as our legislation did not define the hate speech. And the next is no proper definition, right? We don't have a legal definition of hate speech. So even the Supreme Court gets confused. Even some of the judges confuse the as there is no proper definition, there is a frequent clashes between the hate speech and the freedom of speech and expression. Okay, now look into this box. Here two cases are given. The two cases are, the first case is the Pravasi Bhalai Sangatam versus Union of India case. So in this case, the petitioner requested the state to enact strict regulations and take strict actions against the people who are involved in hate speech. But the Supreme Court said that existing laws would solve the problems regarding the hate speech. So this is one case related to this hate speech. So now here the Supreme Court said that the existing laws would solve the problems regarding hate speech, right? Now what are these existing laws? Here we learned the existing laws are Article 19 Clause 2, IPC 1860, RPA Act 1951 and Protection of Civil Rights 1955. So these are the laws that can solve the problems regarding the hate speech. So under this case, the Supreme Court has said that existing laws would save these problems. Second case of hate speech is Shreya Singhal versus Union of India case. So in this case, the issue was this Section 66A of IT Act 2000. Okay, this section gave government the power to arrest and imprison an individual for allegedly offensive or menacing online post. So in this case, there was a conflict between Section 66A of IT Act 2000 and Article 19 Clause 1 Clause A. So here, this Article 19 Clause 1 deals with the right to speech and expression. Finally, in this case, the Supreme Court has differentiated between the two and the case was solved. Okay, so it differentiated between this Article 19 Clause 1A and this Article 66A. So Article 66A, this Section 66A deals with the power to arrest and imprison an individual for allegedly offensive and sensitive post, online post. Okay, so here Article 19 Clause 1 Clause A deals with the freedom of expression. See here, you have the freedom of expression, but you don't have the freedom to criticize or for offensive posts under this article, Section 66A of IT Act 2000. Okay, so this is related to this Shreya Singhal versus Union of India case. And now the way forward is, the Law Commission recommended to add separate offences of hate speech on this Indian Penal Code other than this existing sections. And the second one is, the punishment of the hate speech should be transparent and those punishment should also not violate the freedom of speech and expression. And the third is, there should be alternative dispute settlement on hate speech other than courts, because the settlements can solve the disputes in short time through mediation or negotiation. And the fourth is by introducing alternative or non-legal measures to solve hate speech, that is by involving religious heads, by monitoring social media with new technologies, and by promoting human rights education. So all these are some of the steps that should be taken to decrease the hate speech.